So we are now live. Right, I think we are live.
Yeah. We've got some people joining us.
We do indeed. Guys, if you can let us know in the chat that you can hear and see us, and that would be fantastic, so we know everything works as it should.
We're just going to give it a few minutes past 6:30 before we actually start the webinar properly. But for those of you who are joining us, I'm Catherine, and I work at Samuel Wood, and I'm co-hosting with Sławek, who's the head of lettings. You may have met him before if you've come to one of our webinars. So people are still joining us, and we're not going to start officially until we've let some more people in. So just take a break. Jenny, thank you for letting us know that you can hear and see us. Thank you.
Fantastic. For those who have been on our very first webinar, they know what has happened. Hence, we are very keen to know that everything works. Really, for those who haven't been on our first webinar, imagine our very first webinar being launched and no one can hear us.
Is that what happened?
That's what happened on the very first webinar.
Oh, no.
We were crushed. It wasn't great. However, we did it the following day. It worked brilliantly. We were forgiven, fortunately, by everyone. So hopefully this time around, everything will work really, really well. I think we'll give a minute or two, perhaps, for everyone else to join before we start as well. But yeah, it's going to be a great night.
It is. We've got the next 90 minutes together for those of you who are joining us, and I think we're still hoping for a few more. Give it another minute or so because people might be coming in late after your busy day. But a reminder, if you have just joined us, my name's Catherine, and I'm going to be helping to co-host the webinar tonight with Sławek, who's our head of lettings, and he's an absolute encyclopedia about the Renters Reform Bill. So
you're making me blush.
I'm going to be reminding you a few times throughout the evening, but please do feel free to post questions and comments at any point in the chat. We're not going to be reading them apart from, making sure that you can still see and hear us. But they'll stay there and we'll be coming to them at the end. So we'll make sure that we answer all your questions and comments, won't we?
Yes, that's absolutely right. So yeah, bear with us. If you post a question, we will come to it at the end of the webinar. So by all means, post them. And if there is anything that is not quite clear in the question, then we will perhaps ask for clarification at that point as well. Right. I think if we give some sort of 30 seconds more for any sort of latecomers to join us, and we'll be starting very, very soon. And thank you very much for giving up the sunny day outside. I'm sure most of us would prefer to sort of lounge in our gardens.
That's true, but our viewers can have their beer or their wine alongside this essential viewing, whereas we can't.
No, we can't. No. Just for clarity, that's just a glass of water. Nothing more. Nothing more in there. Okay.
Right. Well, I'll introduce us one last time. I'm Catherine, and I work with Samuel Wood, and this is Sławek. He's our head of lettings, and we're going to be taking you through. This is our 4th free webinar to let you know everything that you need to know about renting at the moment, but in particular, the Renters' Rights Bill. So we've got lots to get through, and please do pop a question in if one comes to you at any point, and we will come to it at the end. So we're going to be here for about 90 minutes, but the last 30 minutes is given over to you and Sławek to go through any questions.
My favorite part of the webinar, by the way.
Of course.
You can never know. You never know what kind of questions will come.
No, in. And I think of them as we go through, so I'm expecting everybody else to as well. So we're going to be going through all of the changes as we know them. There is a lot of information. If you've been here with us before, then it's a good chance to recap. And if you are new, if you've been here, you'll hear about the updates. So we're going to also be discussing what the practical implementations of these changes are, not just what they are, what you can do about what you need to do. And you will need to make changes, really, about how you go about managing your tenancies. And then, as we said, the final part's the question and answer. So let's get started.
Okay, fantastic.
So this bill is going through the House of Lords at the moment. It's in committee stage. It was heard this month, and we're expecting that to finish at the end of the month, the committee stage. Yes,
that's right. And potentially, Labour are pushing for this to, get the royal assent as soon as possible.
Okay.
So potentially, we are looking for, summer where the bill goes through all the stages in the Parliament, and potentially royal assent at that stage as well, with the bill then being implemented sometime in autumn. We just don't know. Government is just not clear how much time they will give. On one hand, they say absolutely nothing. On the other hand, they are trying to assure us that there will be enough time. I'll go to wait and see. But I won't take any chances. We are already preparing for the changes, really to make sure that all our landlords are protected.
So whilst Parliament review the bill, make amendments, the reality is it's very unlikely there's going to be many substantial changes to the existing bill. But there's still sections where they might change things, but that might not actually happen until it's been implemented.
That's so true. So we will mention when we discuss the details. So there are sections of the bill that are being mentioned, but actually the legislation itself is not part of the bill, and it will require secondary legislation at a later point. And if you are keeping an eye on the developments with the bill, you may sort of see, a long list of amendments and changes that are being proposed to the bill. As Catherine said, reality is none of those are going to go through. The government will want to implement the bill as it is.
Because the reality is, Labour has such a massive majority and it's their bill. So
absolutely right. And before we perhaps start further, just briefly to tell us why we have that bill. I think it's important to understand that. So that's because in my opinion, and that's my personal opinion, there is a massive housing crisis in England and in UK, and we end up in a situation where we don't have enough homes to house the population in UK. Over the last 20 years, not enough homes have been built. I think some statistics say that there is about 1 million homes missing from the market that should have been built to fulfill the needs of the population. So, it's a massive gap itself. The prices, therefore, of the houses have gone up, to quite a level. In order to buy a house right now, we are buying a house, worth, 20 or 30 times your salary, whereas in the past, even though interest rates may have been higher, the multiple of your salary in terms of what the house was worth was much, much lower. Really. A big proportion of the population is currently renting. You can see on the slide, it's about 20% of all households in England that are renting. When you think about it, if you put in a line, 10 people, every fifth family is renting a property. What that has led to is to some big political changes because of the failings of the governments over the last 30 years to do with how the housing market has been managed. The only way they can try to fix that in an easy way is to pretend to be on the side of the renters by introducing big changes to the legislation, whereas the change themselves won't fix the market.
No.
We will still be in the same situation, really lack of housing. That's how we arrived where we are at the moment.
So there's not enough council housing. There's not enough private rental. and that's why we're here. That's why we've got this massive shake-up, but it's not going to be enough.
No, definitely not. And we'll talk about that a little bit later towards the end of discussing the renters reform bill.
Great. So should we get started and go through? This is the overview that you're seeing now. These are the main points that are coming out in the bill. Do you want to just take us through, or is everyone happy to read those?
Yeah, I think we'll be discussing the details a little bit later, but those are just the main points.
Yeah.
So, it's not the bill, in the whole. Those are just main points. There's tons of details that go into any of those points, and we'll try to touch on the practicalities of each of those points during the webinar.
If you have joined us before the very start, as we've said, we've got a lot of information to get through. We're going to be going through all the points that you can see there. But if you have any questions or comments, please do put them in the chat and we will come to them at the very end.
Yes, and Catherine will try to keep me in check. I'm a bit of a nerd, and I can start to sort of go on about those things for a very, very long time. And, we don't have all night, really. Right.
So we're going to kick off with periodic tenancies, because that is our first change.
Yes. So the moment when the bill becomes law, all tenancies that are currently, all the existing tenancies that have a still fixed term period to run will automatically become periodic tenancies. So there is no transition period as such. And a new tenancy starting will start from day one as periodic tenancy. What that means on practical level, and perhaps just to add as well, the one change that is to the landlord's benefit, the tenant will have to give 2 months notice to the landlord in order to end the tenancy.
Yeah.
So going through some practical applications here, quickly touching on the tenant's notice. So if the tenancy starts as a periodic tenancy from day one, what that means to you as a landlord, bearing in mind how the law will work around the tenant giving notice, is that the minimum tenancy you could potentially have is a 3 months tenancy, because the tenant's notice must run along the rental period terms. So if they started their tenancy on the first of a month, they notice period will have to start on the first of the month, meaning that if they move in, well, not exactly this way, but generally speaking, when they move in, they will have to give a notice straight away if they wish. That notice will start running at the very start of the second month. 2 months later, the notice ends, the tenancy can end. Okay. So that's the main part of it. Now, realistically, in Shropshire, most tenants that we have are long-term tenants. Mm-hmm. But the landlords will need to change how they approach the applicants interested in their rental property, and having the way of asking the right questions that will allow them to assess whether the tenant is likely to be a long-term tenant or someone who perhaps will be looking at a shorter-term tenancy. So as an example, if we've got an applicant who he has sold the property elsewhere, moving back to the area, rather than asking them, are they looking for long-term or short-term tenancy, because some tenants may very well just say, yeah, I'm looking for long-term tenancy. You've got no way of verifying it. You would perhaps ask more of an assumptive question. All right, okay, I see you're moving to the area. That's great. I assume you will be looking to sort of purchase a house in the next 6 or 12 months. You are more likely to get an honest answer to that question. You won't make a big deal of that when asking that question, but this will give you a vital information. That is the kind of a way you will need to approach those kind of conversation and assessment, really. And it will be an important part.
So they can give 3 months notice essentially, but they're also protected for 12 months. They have protection.
That's absolutely right. So a great deal is changing how the landlords can get their property back. But this is extremely important. While from the tenant perspective, the tenancy is a periodic tenancy from day one, so they can vacate at any point by giving 2 months notice. For the landlord, actually, it's a minimum 12 months tenancy, because we will discuss it in a moment. The earliest the landlord can try to have the property back is at the end of the 12 months period.
Because this is the renter's rights.
Yes, that's a very good point. Very good point.
So on that, we're abolishing Section 21.
Yes, that's absolutely right. So most of us would have heard that's the headline. Section 21 is no longer here. The reason for that is quite simple. It is being said that it's so-called no-fault eviction, and somehow the people who are fighting for the renters' rights try to say that landlords are using it left and right for no good reason, just simply because they think it's fun to evict tenants, really. Whereas the reality of my working as a letting agent, for over 17 years, the only times I've ever served notice on landlord's instructions, if there was a reason for that. Landlord wanted to sell their house, landlord wanted to move back in, or the tenant was in rent arrears. I haven't seen any other reasons, really. Fortunately, the new grounds on which the landlords will be able to claim the possession back are changed and ensure that if you need to sell the property, you can do so. You can serve the notice to the tenant. If you or your family member is looking to move into the property, you can serve the notice on the tenant. And if your tenant is in the rent arrears, you can serve a notice on the tenant.
But the notice is a bit different.
It is. The practicalities, again, are really quite different. So firstly, when it comes to selling the property, again, it will require the landlords to think very, very carefully and put a lot of consideration before they make that decision. Why? Because the notice is a 4 months notice. That means it's a much longer period leading to a point where the tenant will need to vacate the property before you can then put the property on the market. But most importantly, you won't be able to relet that property for the 12 months after you got it. You have the property back. So what that means practically, if I have a property, I've decided to sell the property, I'm hoping to achieve, X amount of money for that. It goes on, eventually the tenant vacate, the property goes on the market, and I'm getting the offers below what I'm expecting. I have no way back. The only two options I have is either to accept lower offer or wait until the 12 months go by to be able to relet the property.
And we talked about this earlier. If you give the 4 month notice because you want to sell the property, but they move out, quickly, and you don't sell it, you can't really get somebody else in. That's
absolutely right. It's if you handed the notice because you are selling and the tenant has vacated the property during that notice, that rule will still apply, really. So I think this is one of the more significant changes in how the landlords will need to approach being a landlord, running that landlord business, because it will require a lot of planning and far more consideration when making that decision to sell the property. The next step is section reason is, as we've mentioned, if for any reason you or your family member and the family is sort of defined as a quite wide circle, but it is a strict definition. It does not include, uncles, aunties, nephews, nieces. But everyone else, yes. Then again, you will be able to serve the notice in order to move to the property. That doesn't happen too often. But the last one is when you need to give the notice because of the rent arrears. Again, a second significant change in here, because it's a big change to what we have at the moment. At the moment, the landlord, if the tenant is in 2 months rent arrears, the landlord needs to serve 2 weeks notice. And when if the tenant does not vacate the property at the end of that 2 weeks notice, you can go straight to the court. With the bill, the tenant will need to be 3 months in rent arrears, and the notice period will be 1 month. What that means is that by the time you can start court proceedings, if the tenant doesn't move out, the tenant will be in 3 months rent arrears. So it's a much 4 months in rent arrears. Pardon me, 4 months in rent arrears. So again, and it requires the landlords to have a very, very careful think about their financial situation and position, and thinking about what happens if I have a situation where my tenant is not paying the rent for 4 months straight. What kind of a situation will that put me in as a landlord?
Right.
And as we discussed earlier, that's only the beginning of the process.
The court could take a long time.
Absolutely right. I think it will be absolutely paramount for every landlord to have a rent guarantee in place, rent guarantee and legal protection in place.
Yeah.
It will be absolutely paramount. Unless someone who is, I don't know, lucky enough to be swimming in money and, leisuring somewhere on a Greek island, and it really doesn't matter to your bottom line. But, there aren't
most of us.
Unfortunately, it isn't really. So, that's another big change.
So that's if we are in deficit. But if you want to consider putting your rent up, which we suggest that you do annually or following the market, there's a change there as well, isn't there?
There is. I want to say yet another big change. Really, there is a lot of those big and significant changes. Yes. So currently, there are 2 ways of increasing the rent. Most landlords tend to have a conversation with their tenant, and the tenant, as long as the tenant agrees to the rent and starts paying the new rent, and new tenancy allows for that as well. That's it. That's all that is really needed. That is changing. And the bill will require for the rent increases to be done in an official way by serving a Section 13 notice. It's rather complicated notice, shouldn't have been, but the way it was drafted, it rather doesn't quite make sense in certain parts of it, really. And it has to be a 2 months notice. So again, it's a longer window actually to from the point when you serve the note of where you decide to increase the rent, have the conversation with the tenant, serve the notice, to the time when that new rent actually applies. It can easily be 3 months really. So that is the big change. But probably the most significant element in here is a very unfortunate part of that, which is the right of the tenant to apply to the first-tier tribunal to challenge the rent increase. The tenants can do so currently as well. Okay, the tribunal can take up to 6 months to make a decision. The tribunal can decide to either decide that the increase should be lower, should be as the landlord is asking, or if the landlord is asking for less than what the market rate is, the tribunal can decide that the increase actually is higher than what the landlord has suggested. So if very few tenants challenge that increase, because they are running a risk to having to pay a higher rent. But most importantly, even though it can take up to 6 months, the rent increase is backdated to when it should start. So
when you ask
that's
for it as the landlord.
Absolutely right. So if there is a delay when there is a delay to the process, but it is backdated. So the big significant change with the new bill is that as it's going to be, Once the tribunal makes a decision within the renters reform, renters rights bill, the new increase will apply from when the tribunal makes the decision. So when you think about it,
you could be waiting 6-9 months for that money to come in.
Absolutely right. And the tenant is quite literally incentivized to, every time when you increase the rent, to apply to the first year tribunal to delay the rent increase. It's literally in the interest to do so, because it will not only delay when they are starting to pay the increased rent, but it will not be backdated. And the right of the tribunal to apply a higher increase than the landlord have applied for is no longer there. So the tenants are not risking having to pay a higher rent than the landlord is asking.
So if they know about this, they may well do it.
Unfortunately.
Yeah.
And again, we'll talk about it later. I mean, if you've got a good tenant, let's touch on this subject briefly. When you've got a good tenant, the chances are, perhaps, not that great. But when you've got a good tenant who is pressed financially or pressed in some other way, or finds themselves in a situation, difficult situation, you will have a good tenant who will still do that. Really, because ultimately it's in their interest.
Yeah, they want to stay
to do so.
as well.
Really.
Okay.
So just to finish that party, that means it's going to be crucial for the landlords to ensure that they do rent increases every year. They start the process early enough so that the rent increase starts to apply every 12 months. Because if you have a tenant that is going to delay that process, you may have the increase being done every 18 months.
And of course, just quickly, Sławek, if you haven't put your rent up and it's not at market value, you could try now before this comes into force. You can be thinking about it now.
Thank you very much.
Yeah.
Absolutely right. We are doing that actually, and speaking with quite a few landlords who haven't increased their rent for quite some time. It's crucial you do so before the bill comes in. So if you are quite far behind with the market rate because you had a good tenant for 3, 5, 10 years and you never increased the rent, then your rent will be very far behind the market rate, which in itself is a really, really bad thing to happen. But that's conversation for a different night. Really.
Okay, great. So, moving on, bidding wars, which do go on, and rent in advance. What's happening there?
Yes. So, firstly, the bidding wars, quite straightforward. Means the landlord cannot ask the tenants and cannot accept a higher rent on the property than it's advertised. So that means that if you market the property or an agent does so for you, at, I don't know, £1,000 per month, and you've got several tenants who are very keen to rent the property, one of them will offer a higher rent. It does happen often enough, actually, these days. You will not be able to accept it, even if the tenant does so voluntarily, without you saying anything at all. You cannot. You will be breaking the law. So that's very straightforward. And then basically what that means is that you need to put the property on the market at the market rate, really, because you will not be able to start the tenancy at a higher rent than when you advertised. Now, rent in advance.
Yeah.
So I'll divide that into two separate sections, okay, for the simplicity, because it is very complicated. Firstly, landlords will no longer be able to ask for a rent in advance. For example, you've got a tenant who's got a bit of a risky profile, but you are still willing to accept them as a tenant. It's relatively common practice to ask them for 6 or 12 months rent up front. It can be a tenant who is moving back to UK from sort of living overseas for a period of time. It can be someone who is just moving like I did 20 years ago for the first time to this country. I've got no credit history at that point, and many other things that making me that bit riskier tenant. It's common practice these days to ask for rent in advance. And obviously that applies in many other situations where perhaps there is adverse credit history and so on. What we will not be able to do that is asking those kind of tenants for pay the rent in advance. And the terms of the tenancy you will not be able to have any terms in the tenancy that would say the tenant needs to pay 3-6 months rent in advance or anything of the sort. They will not be binding. Okay, so what that's likely going to do is going to have an impact on those kind of tenants who were still able to access rental market by having that ability to pay rent in advance. That's no longer going to be the case. Now, the more complicated part, and I'm mindful we are limited on time, that is, and so I'm going to try to explain it relatively simple as a process. And quite surprisingly, that second part means you are not able to accept first month's rent in advance of the tenancy of signing the contract. And I'll let that sink in. So we found the tenant for a landlord. We are doing the checks. The checks have been completed. Everyone is happy to go ahead with the tenancy. Currently, we are asking the tenant to pay the rent and the deposit. Once received, we move on to signing the contract. With the new rules, we will not be able. What we'll be able to do is, once the checks are completed, we will ask the tenant to pay the tenancy deposit, the 5 weeks rent, but we will not be able to ask them to pay the first month's rent until the tenancy itself is signed. Implications of that are that the tenancy will be signed on a given date, so it will become a legally binding contract, but it will not start until several days or a week later, just to give enough time to ensure that the first month's rent is collected. So that is rather quite unexpected change. I don't believe that the government have intended for this to happen, but we know how it is with drafting new legislation.
The risk is someone could go into arrears straight away.
Yes, absolutely right. There is risk. There is risk of that. What landlords can do and need to do, obviously, is being that a little bit more careful in selection of the tenants. Yeah. That means really that you probably need to be a little bit less more risk averse as well. I go back to the rent guarantee and legal protection in place, which will help with that as well. But realistically, that there is nothing to protect you 100% from that happening.
Not even the contract. It is a legally binding contract.
It is legally binding contract. So the contract is signed. The tenant hasn't paid the first month's rent. Comes the date when the tenancy actually starts. Okay. And you will not be able to refuse the keys to your house. There is a talk about trying to have some workarounds with certain terms within the contract. We'll have to see how that's going to look. But there is a big warning with any workarounds. And you probably the best example is all the tax rules and all the examples of various schemes that are supposed to help you minimize your tax that you need to pay, which then later on, sometimes much later on, are ruled to be illegal or misinterpretation of the rules. Actually, things like that can sort of come and bite you at a later point. So I would suggest to be extremely careful if you're going down the path of trying to find a workaround, because what the government is doing is being very careful with the bill to try to close any loopholes within the bill that could make the landlords trying to use them basically, and they've done so already. But the slightly more positive side is the reality of the market and of life is that most tenants will want the house, and most tenants will pay the first month's rent. The chances of a situation happening where the tenant doesn't pay the first month's rent and moves to your property is pretty low, especially in Shropshire. But it can happen, really. So going back again, rent guarantee and legal protection. It's yet another reason that it's absolute must.
So as well as looking after them financially, we need to look after them with the state of the property, which we all know we should be doing anyway, but we've got the decent home standard, and we're going to also talk about AWAB's law.
That's absolutely right. So the decent home standard have been introduced into the social housing. Actually, it's not yet, it hasn't yet started. It's taking place later this year, but that standard in some form will apply to the private rented sector as well. We don't know exactly in which form this is going to happen, so we will have to wait for more details. But what this can mean on practical level is that perhaps you will be required to ensure that your bathrooms, your kitchens are sort of modern enough, really. So, for example, if you are buying, and as I said, we don't know for sure how this exactly going to be implemented. So if I'm a landlord and I've bought, or you're a landlord, and you are a landlord, aren't you? If you buy a house that perhaps needs some work done, but you either don't have the time or don't have the funds to do so, and the kitchen is rather quite dated. The same goes for the bathroom. What that means actually is, depending on what the law will exactly say, is that actually you will have to do that before you can let that property. And then it goes further to the point that as a landlord, you will start to have to plan quite far into the future to ensure that you have a pot of money ready there to do all that work. Because let's face it, most of us, you are a landlord, you have bought the property with mind to keep it long term. Mm-hmm. A lot of landlords are using that as their pension pot. 20, 30, 40, 50 years, if you are lucky. Which means you will have to do those things at some point. And there is nothing better to the comfort of knowing that you do have a pot of money sitting on the side to be able to do that when it's needed or when you make that decision.
So as well as kitchens and bathrooms in a good state, we also need to think about things like damp and mold, and that you've got to do it in a decent time frame.
Yes. So AWAB's law, I'm sure everyone is aware of the sad case of a young child who has died because of living in unhealthy conditions. It was to do with with the mold, really. So what the government did, they again brought the legislation for the social housing sector, where they imposed quite strict rules on what the social landlords must do when issues are being reported or issues are being found, in terms of how quickly they need to attend to them. The timescales are dependent on the severity of the issue and the kind of an issue there is. So, as an example, you say if it's a middle of the winter and boiler packs up, you may actually have simply 24 hours to take action and to make things happen. Again, we need to wait what exactly the implementation will look like of that law to the private rented sector. So it's yet another on the list. Let's wait and see how the detail actually going to look like. So
the Ombudsman, we've got quite a lot to say about that one, though, haven't we?
We do, and I'm mindful. We need to keep to the time, really, but. Significant change here, a big change, in my opinion, a bigger change than abolishment, or as big a change as abolishment of Section 21 notice. To keep it relatively short, Ombudsman will be a body that every landlord by law will have to belong to. And it's a place where the tenant can go and complain on their landlords if they are unhappy with anything with the landlord or with the property.
Yeah.
Ombudsman will have all the ultimate outcome of that complaint will be that you as a landlord will need to apologize, perhaps if the complaint is upheld, obviously. You will need to apologize to the tenant. You will be given order to fix the whatever the problem or issue there is. You will be asked to pay compensation. I'll let that sink in. Compensation. So again, another incentive for the tenants to consider using Ombudsman, or rent repayment orders, where you will have to actually repay the rent back to the tenant. And we'll discuss this in a little bit more detail at a later stage. But it cannot be overstated how big an impact this will have on running your business, really. And to add that it's not just your tenant who can complain to Ombudsman, your ex-tenant will have that right. So any tenant who might feel perhaps not very comfortable doing so right now, someone who you might be thinking is a good tenant, you may have a good relationship with them, but they might be the kind of person who, is rather uncomfortable to have a confrontation with someone. Well, they might change their mind when they move out from your property and find another one.
Do they have a period of time to do that within?
You cut me out there. There will be a time of a period. I believe it's 2 years, but don't quote me on that just yet. And it is mandatory for the landlords to be part of Ombudsman in order to let the property.
Okay. Should we go on then?
Yes, so let's move to the next point.
I just remind anyone, if you have got any questions at any point, pop them in the chat and we will come to them at the end. So the PRS database, Slavik.
Yes. So yeah, mindful of timing, we'll keep that short. Again, it's another body that the landlords will be required to be registered with. Again, you will have to pay for the membership. The same goes for the Ombudsman I previously mentioned. So additional cost to the landlord. We'll have to wait for details on how that database is going to work. But the idea is that it's going to be a place for landlords to have everything they need to be good landlords, to keep up to date with legislation and with the practice. But a place as well where your compliance can be checked. So, a tenant or a local authority will be able to check to ensure that everything is in order. So the likelihood that you will have to upload the gas safety certificates, electric checks, and all the other documents as well. So that's in short about PRS, especially that we are still waiting for more details. But it's going to be mandatory to be a member of the private rented sector database.
Okay. And discrimination of certain tenants, they're going to be more protected now. Obviously they should be, but let's go into that one.
Yes. And it's just to add about the discrimination, we've long ago have adjusted our practice as well. So nothing is changing for our clients as such. But what that means is you will no longer be able to advertise the property as, no housing benefits or no children. So if you've got, a 2 or 3 bedroom home, and so far you had, a single tenant or sort of perhaps just, older couples who, whose children already left the nest. And you're advertising the property as no children to let everyone know that you're not willing to accept them. You will no longer be able to. You will be able to do so. And there actually is already some. I want to say case law, but there were some cases in courts that were settled out of the court in relation to some of those out of those aspects. So I would encourage everyone to be extremely careful how they go about advertising and looking for their tenants, and have that in the forefront of their mind when they do so. as a landlord, you still will be able to decide who rents your home. So that right is not being taken away from you. But if a landlord who blatantly discriminates a certain group of tenants, then yes, you are running a risk into getting into an awful lot of problems, ending up with fines. Absolutely right. And think about it as well, with ombudsmen in place as well, with local authorities being more sort of on it as well. I don't advise that.
That's an interesting one though, Slawek. Landlords can turn down applicants on the grounds of affordability.
Yes. So that goes to sort of you as a landlord still being able to decide who your tenant is. So it doesn't mean you have to accept everyone, but perhaps, let's say a scenario where you have a property on the market for whatever reason is sort of not really letting very quickly. No one is really interested in the property, and then you receive an application. So there is a viewing. You receive an application from someone who perhaps doesn't quite fit your criteria. There is nothing wrong with the application. They sort of meet all the criteria. You have to be extremely careful how you approach refusal to let the property.
So that brings us to the next one, which is the pet. The pet is quite a sticky point for a lot of landlords, isn't it?
It is. I think we are looking at about at least half of the landlords not accepting pets.
And you can understand why, especially if you've just done a property out, it's brand new, and you're trying to protect it. I can understand the reasons. But
I absolutely can. And I'm a pet owner myself. I'm a proud owner of two house cats, and I wouldn't part with them ever. So I can see that the other side as a pet owner.
Yeah.
But the reality of it is that if you are renting a property to a tenant with pet, it comes with a higher risk, and it's not anything to do with the pet themselves. It's actually to do with the pet owner, your tenant. Are they responsible pet owners? Because that is what's causing the trouble. Fortunately, so just for clarity, as a landlord, you will not be able to unreasonably refuse the permission for the tenant to have a pet. Okay, and you will be able to ask the tenant to either take on or pay you for you to have a specialist insurance against damages caused by the pets. The insurance market is still working out the details of those kind of products. I think I've seen one already somewhere out there, but we'll again have to wait for more details from the market this time around, how those insurance products are going to work.
Do you know, or do you think that there could be a scenario where someone applies, you accept them, and then they reveal they've got a pet to try and get around this?
100%. Okay. There is no question in my mind. But it's not even about getting around this. Often enough, people are moving into the property. They have no pet. They perhaps, are well settled. Something perhaps is changing. We are not pet owners from. There's always a point in time when you become a pet owner, really. So that can very well, and it will happen with your tenants,
Or you could have my situation where someone moved a rabbit in between inspections, and it ate all the carpets, and they never declared it.
Seriously?
Yes.
Right. That is an extreme example, and this is what I mean by responsible pet owner. It's not the fault of the rabbit for having done it, really. Rabbits do what they do.
Who knows that a rabbit would cause that much havoc?
No, that is the first time I hear that. Absolutely right.
First time for everything with me.
But quickly on the practical level, okay, just for you as a landlord to protect. So, while you cannot unreasonably refuse the pet permission for the tenant to have a pet, you do have a right to do so if the circumstances are such that you should. So I would put it into two different sort of parts. One part is to do with the house itself or the circumstances around the house, where, for example, property is in a rural area, there is a livestock around, and you have a good reason to qualify that as a high risk. For example, you will have to have a really good reason for that, very well. What's the word? Evidence. Absolutely right. So, for example, as an example, we've got a client, rural property, fence all around the property just as well. There is a drive going by the property, and the livestock goes up and down that drive. In theory, there should be nothing stopping that tenant having a pet. But what happens in a situation where the owner forgets to lock the gate, and the dog actually gets outside through the gate? In my opinion, that's potentially a reason to refuse a pet. But if the tenant is unhappy with that decision, they will be able to challenge that through the ombudsman, and you got it guaranteed that that's going to happen. So you have to have a very good evidence. The other side, the practical side, is think about it already. To have when tenant asks for a permission to have a pet, have an application for them to fill in with all the various details about that situation. So, for example, ask them what arrangements they have for when they go away on holiday, what arrangements they have when they go to work without no one being at home for 8 hours. What arrangements they have in terms of being registered with vets, vaccinations, and so on. Because if you refuse permission for a pet, having this in place will give you a much better chance for your case to stand up if the tenant challenges you at the ombudsman. Because remember, you will have to defend your decision rather than a tenant having to prove they right, because they will have that right already.
So we've got about 20 minutes left, I think, to go through the remaining slides before we get to the questions. But we have got an offer for everyone that's here that I'm going to put in now, if that's all right, because we're not sure if everyone, if you're not going to quite make it to the end, we want you to have it. So you can book in a free call with one of our experts to discuss anything that we're talking about in more detail. We've got your questions coming through, and we will definitely get to them at the end. But we are offering you a free tenancy health check on your tenancy. It is no obligation. We just want you to have a chat with us, and you can find out a bit more in detail about your own personal circumstances. So that's there. You can schedule a call whenever it suits you.
Yeah, if you click on the link, it will take you to a separate page to register. But you will be able to go back into the webinar itself. I would encourage everyone who have sort of more detailed questions or sort of general conversation about their portfolio, and how they position themselves as landlords in the market that is going to be substantially different to what it is.
And you say portfolio, but that's a one property to anyone. We want to talk to, we can help anybody here. So let's go back into the webinar and penalties and enforcements, because this one caught me out when we were chatting before, and I'll tell you why in a minute. But you can penalise.
Okay. Yeah. So big part of the and here it is again, big part of the renters' rights bill is introduction of penalties and the way of the bill being enforced. So virtually most of the elements of the bill, so like registration with ombudsman, with the private rented database, your obligation under decent home standard, and so on. Failing to sort of to align with those, virtually every of those elements carries a penalty up to £7,000 and £40,000 for repeat offenders. Really, So the government, again, what it is saying to everyone is we are extremely serious about it. You must follow the rules, and we will penalize you if you do not do so. And with the introduction of the ombudsman, you can actually end up being penalized, not even when the local authority is not involved in the process, where it's simply by the tenant complaining to the ombudsman, and that can as well result in some rather unpleasant consequences. And the councils, the local authorities, are being encouraged by the government to be more stringent with their enforcing. We've been relatively lucky with Shropshire Council. They are quite reasonable and approachable when it comes to sort of the situations where they are getting involved. But I have no doubt that the bill will result with many landlords who unknowingly will be breaking the law, ending up with fines. There's absolutely no question about it.
And it's not just going to be people with a big portfolio or who are running multiple HMOs. It could be anyone.
Yes, that's actually a very good point. Council is not after big or small landlords. They are not after a landlord as such. Their focus is the property and the issues with the property or the issues with the tenancy. So if it happens to be owned by a landlord who owns only that one property, it makes no difference really whatsoever.
Yeah, it's not like the government going after a massive tax fraud because they're going to get more. It's just the property. Yeah.
The aim is to enforce the bill. So if you own one property, or if you own 100 properties, if you are fined to have broken the rules, you will be treated in the same way.
Okay.
That's very very important to remember, really.
So, as the slide says, what does this really mean? And no one is talking about it. We need to run it like a business now, don't we?
Yes, we do. So I have a very, very sort of personal relationship with this bill, having been looking at it, studying it for quite a long time. I think it's very important for anyone who is a landlord to zoom out and look at it, what it means in the big scheme of things. I think it's extremely important because it will put everything else in the perspective, in the right perspective. So, firstly, you see, some sort of words on that slide. The bill will force the rental market, the landlords, to become a professional landlords. It will force the professionalization of the industry. Really, there will be no longer place for landlords who are not treating that seriously. And I'm not saying that I don't mean it in a bad way. It's just that I know so many landlords who own one, perhaps two properties. In some cases, they've inherited a property, so they haven't quite planned to be a landlord, but they are ending up being a landlord, or they decided it's a good idea to let the property rather than sell it. And while right now that decision might sound like fairly straightforward, actually, once that bill becomes law, it's going to be a much serious consideration. You really, if you're not full-time landlord, if you're not someone who pays attention to the developments in the private rented sector, you will have to start doing so. There is no other choice, really.
You put it very clearly to me earlier, Sławek. If you bought any other business for say £200,000, and you just didn't look after it, and you just expected it to make you money, you might fall foul. You might run into trouble with the law. So we need to look at this investment of the say £200,000 to buy the property as any other business. You've got to help it work harder for you.
Yeah, I feel extremely strongly about that. And I'm a little bit upset with some landlords I speak with. Well, upset perhaps is too a strong word, but I feel upset actually with myself when I don't manage to convey the importance of that to a landlord I speak with. Really seriously, I mean, if I bought a property, whether that's for cash of £200,000 or whether I've taken a loan, if I did so to buy a business, would I go back to my day job and hope that the business will just run itself? Really, paying a scant attention to it. Would I do my accounts and my taxes? Deal with whatever legislation in my industry requires? Would I be looking to be doing that myself while actually not working in the business, day in, day out, being a full-time landlord? Well, the likelihood is that business would go under. So translating that to your being a landlord, you probably won't go under, but you are running risk to have severe penalties, and actually finding yourself with the changes that are in place, finding yourself in a situation where the only way out is to hand the notice to the tenant to end the tenancy in order to sell the property. Because with the Section 21 notice being gone, if there is an issue along the way, you no longer have the easy way to do so. And if you run into such a massive problem that this really doesn't work any longer, you don't have an option of ending the tenancy and hoping for better tenants.
So I'm a landlord and I work, and I don't have the time to run it as the business that it deserves, especially with all these changes coming in. So for me personally, the peace of mind of someone knowing all of this and having those discussions with the tenant is like having a manager of my business, which I think is really important. And it's someone who has the knowledge to manage it properly. But we've also talked about, a lot of landlords have people in their property that they know or that they're friends with or they're very friendly with, and that could slightly change with the way that this bill is changing things for them.
Yes, that's a very good point. So we are going to that third point of tenant-landlord relationship. The bill will quite literally pit the tenant against the landlord and landlord against the tenant because of how the bill is done. So landlords have no option. They might be friendly with the tenant, but this mustn't stop them running this tenancy and the property as a proper business, really. So there is a time to be friendly with your tenant, hoping that will help, things, run smoothly along, but it cannot stop you to know where to put your business hat on to deal with the situation as you should, really. Because let's remember one again, you may think that everything is great, and you may find that things haven't been great from the tenant side when they move out and make a complaint to the ombudsman. So that's one thing, and the other thing is again, with the abolishment of Section 21 notice, there is no easy way to end something that perhaps have been a really good, turned into really quite a bad tenancy. Really.
Plus, there's a feeling of being backed, I think, having a professional agent, and it's important as well that we talk about a professional agent, because this whole bill is going to weed out those that aren't helping their tenants look after their properties properly. But I don't want to have those really tricky, difficult conversations, and I want the professional backing to help me run the business properly.
Yeah, I mean, listen, there's nothing necessarily wrong, with being, running the portfolio yourself. But the reality is, for you to, be a full-time professional landlord, if you have just one property, is it doesn't really exist. It's not making enough money to for this to be a practical solution, really. The next point we've got, again, something very important to bear in mind, that the practicalities and case law. So what we mean by that is that the current legislation, existed for 30 years. We've got very well established procedures, rules that we follow, case law that exists where the law actually has been tested in courts, and in many cases have surprised people the way it was interpreted as well. All that, or most of that, goes out of the window. We are going to be starting with a blank piece of paper. All the rules and the procedures that will be put in place will be based on the interpretation of the law as it actually comes in. But once tenants start complaining to ombudsman, once things start going into court, we will then truly understand how the bill actually is interpreted. And I'm sure that the end result will be that what we think is the case now, in a year's time, that interpretation is out of the window. We actually have to adjust it. So again, if you run your own portfolio, it's paramount for you to keep up to date with what's happening, because you don't know when that might happen, and you don't know as well what how far-reaching those changes and consequences of the interpretation can be. I think that is point that is not talked about enough really. I'm mindful we are really sort of close running to the time. So the last point is about the rent. I touched on that previously. You must make sure you charge the rent that is market rate. I think the times of being, a nice, good landlord who have not increased the rent because you've got a friendly relationship with your tenant, and you don't really want to increase the rents because good tenants means not increasing the rents, are absolutely out of the window. By the way, that's already not true. But okay, it is what it is. Once that bill becomes law, if you are not increasing your rent every year, you are not running your business properly. You are not building the pot of money needed for speedy repairs. And look, with decent home standards and AWAB's law, okay, when the bill might actually require you that if your boiler breaks down in the middle of the winter, you must fix that boiler, I don't know, within 24 hours, within 48 hours. Whose local contractor is going to be able to do that? No one. The likelihood that your friendly plumber who doesn't charge you a lot for the work is going to be able to do that are, probably quite small, especially in the winter. So you'll have to be looking at some large company who've got the manpower and the availability at a very short notice. And obviously what that means, much higher bill for the same work. So it's paramount to ensure that you charge the appropriate rent and you build up that pot of monies for all the upgrades you need to do, for the repairs you will need to do. And listen, being a good landlord means having the money to redecorate the property, change the carpets between the tenants. It's not about charging low rent. It's actually about making sure it's a nice home for your tenants. So that's my sort of big zoom out and sort of overview of the bill itself. Now, again, I'm mindful we're sort of running on low on time. So I think we are very briefly going to touch on the topic, which we will be talking in far more detail probably on our next webinar, which is the changes the government have already looking at introducing changes to the EPC. Okay, so the main headline, which most of us are aware, is that the new rules will require all rental properties to have the minimum EPC rating C. Currently, it's rating E, so it's quite a low, and even a lot of most of rural Shropshire properties are meeting that rating. Okay. The new rules, which are likely to apply from late 2026, will require the properties to have rating C. However, the crucial part within those changes that is going to probably be as important is that the way the assessment is being done is going to change, and it really changes quite a lot. I really need to actually go back to my notes as well on that, to be quite frank. But Currently, the PC assessment and the rating that the property is given is based on the overall cost of heating, hot water, and lighting the property. Okay, so what that means is that, you know, potentially you could have a property with single glazing throughout, but as long as you had a gas boiler, most of the time you were right, because the gas is a relatively cheap form of heating the property. So you wouldn't need to put a lot of effort to hit the minimum rating in order to be within the law. With the change that is going to come, it's going to be a completely different assessment. So the cost will no longer be the main driver or driver at all, really. It's going to be about how well the property retains heat.
Yeah.
So the same property that have a minimum rating of E, for example, or D, with a gas boiler, single glazed, with the new rules, is likely to have a lower rating, because obviously it's all going to be about the insulation, about single and double glazing, cavity wall insulation, and things like that. This is what is going to be driving the rating. The other aspects will be on how well performing the form of the heating is. So, for example, things like heat pumps, solar panels will be having sort of a much better rating than potentially a gas boiler, really. And then the final metric will be how smart ready the property is. But again, we are waiting on the details on all those changes. Really, there will be some grants the landlords will be able to apply, but there are strictly defined rules about those grants as well. And probably the one thing that we still need to say about it, even if we are keeping short on time, is that the minimum amount of money you will need to spend on upgrading your property to try to reach the level, the C rating, will be between £10,000 to £15,000. It's only once you reach that limit, and for most landlords, it will be £15,000. So that's 1.5. You will have to spend that amount of money before you can apply for an exemption to say, listen, I've done everything I could. Spend £15,000 is still not C. So again, going back to the rent you are charging, it really is quite a different background to being a landlord, or is going to be. You have to run it as a business, do more long-term planning. Now, on the next webinar, we'll dive into more details on that, because the detail is important. There are things you can do to protect yourself, really, but we just don't quite have the time this time around for it.
I'm keen that we can get to our questions. So if you haven't sent a question in yet, please do. But let's pop the offer up again, so that if you want to call, it's a no obligation chat, but our experts, Slavek, we can go through your own personal property or portfolio with you and help you with any questions that you might have. The way that it's set up here is that you can schedule a call at a time that suits you. And perhaps while we're leaving that up for a second, this is the time to pop your questions or comments in the chat, because we're going to be coming to those now and going through them.
Yeah, my favorite part.
I've seen quite a few coming in. Some of the questions which we can probably talk about from my memory while people are having a chance to book a call if they want to are people going to get the slides? Are people going to get a recording of the webinar? We've had a few comments and questions about that.
Yes, so we will be happy to share the slides. Really, there will be my email address at the very end of the webinar. So just pop me an email, and we'll share those slides. And yes, the recording of the webinar will be available as well. So we will share that within a couple of days of the webinar. So
someone asked if it would be this week, so
I would hope so. But bearing in mind we've got Thursday today, hopefully, but I cannot promise for sure. But Monday should be the latest you should have access to the replay of the webinar.
So from my note taking, Leicester.
Okay, let me switch off the offer.
Was one of the first questions.
So we can be seen.
Yes.
Really, we are famous by now, I would imagine. Right.
Right. So we'll just find it go down slightly. So the first question I think we saw was, if the tenant leaves of their own choice, does the 12-month restriction still apply?
No, it would not apply, because the tenant would give you 2 months notice to vacate the property. They move out from the property. You are free to do whatever you want.
Is that, I think Leicester might have been putting that up in relation to when we were talking about, say you want to sell the property and they've left within that time, can you still not rent it out for 12 months? I think if you haven't given them notice,
yes.
It's a grey area probably.
My understanding is that the law will apply. I must admit, it's not that I know for sure, but what I know about the bill and the government's approach to the bill is I would be very surprised, really, if you would then be allowed to relet the property. The 12-month rule would not apply, because the way really to look at it, the tenants are vacating because you serve them with a notice that you wish to sell the property. Even if they end up vacating a little bit earlier the property. So I cannot see that this could be a way for the landlords to have that option to relet. I think we've got a question from, or sort of Alexander has been making a point. The government plan to make lettings so difficult we have to sell up. Alexander, the point I probably would make is going back to my, zooming out of it. I wouldn't necessarily say so. It's what the government is not saying is professionalization of the industry. And yes, you are quite right. It can force some landlords to sell, because one thing we haven't said really is that once the rules, come in later this year, the landlords will have to sit down and think very, very hard what they're going to do next. Okay, because they have to decide firstly whether they wish to carry on being a landlord. Okay, that's the first conversation you need with yourself. Do I want to be a landlord? Do I want to have the property as my asset and sort of letting it to tenants? How that works with my sort of big plans, my big financial plans, and so on. Once you make that decision, you will decide that either yes, I wish, or I know, I don't. If you don't, situation is quite simple. You are going to sell your property, okay? But if you decide that you don't wish to do so, or it's not the right time for you to do so, then the next conversation you need to have with yourself is, am I going to want and have the time to become a full-time professional landlord or not? Because if the answer, and you have to really honestly ask that question yourself, of yourself, and answer it honestly. Because if you don't, you are going to end in trouble. And that is guaranteed with the new legislation. And if the answer is no, then your really only option is, in order to be a successful landlord, is to have someone else run your business, as Catherine has said. Really, because if you try to do so as a part-time landlord, that's no longer an option. So yeah, directly, it's not government trying to force landlords to sell. It's not in their interest, really, simply because that means there is less houses available to rent. And while some people who advocate the tenant rights are saying that if the landlord sells, that means there's someone else's can buy the property as their home. Well, that's great, but if I'm a tenant who's been given a notice to move out because my landlord is selling, that's not great for me, because I need a rented property, and there is now one less rental property on the market available to me as a tenant already. So no, that's definitely not. But I can see how that can appear.
So there's one from Amy. Yes, we're going to send slides over. Can you refuse a pet? That's an interesting one. Can you refuse a pet in a second floor flat?
It depends what kind of a pet that is. Okay.
A horse.
Yeah, that would probably be quite an easy one. So if it's a permission to have a house cat, most definitely not. I cannot see how, on what grounds a landlord could refuse a tenant to have a house cat in a flat.
Okay.
If it's a dog, perhaps, but if it's a small dog, and they've got sort of they are not necessarily working, they've got the time to sort of keep the dog entertained, take them on walks and so on. Again, I think that is open question whether you would be able to refuse. So this is the part where we will have to wait how this is being interpreted, where the permissions are being refused to the tenants. Tenants are then taking those cases to ombudsman, which is free for them to do so. So there is no reason for them not to do so, and we'll just have to see the interpretation. But let's remember that when you are refusing the permission for the pet, it's going to be extremely important how you went about deciding to refuse that permission. So that what I mentioned about literally having an application for the tenant to fill in, so you can then evidence the reason why you said no to them.
This isn't a question, but it's an interesting comment from David. If someone doesn't hit the criteria for rent guarantee, then perhaps you don't rent to them. So that's a reason to have the rent guarantee.
Yes. Listen, David, we already have clients who have, whose condition of letting a property is to have a rent guarantee in place. So if the tenant does not meet that criteria, they will not let the property to that tenant, really. So that's sort of quite straightforward, and it's already in place for some of the landlords, really. What about the one from sort of David here? If you can read that one here.
Yeah, the government and the housing targets. You want me to read it out?
Yeah.
So the government, no, they won't hit their housing targets, even though those new social houses won't be allocated to some of the tenants we currently manage. Therefore, to stop lots of homelessness, they are bringing in legislation that prevents landlords leaving the market.
I guess that goes back to the question about what that bill, an abolishment of Section 2021. You will have the right to sell the property and leave the market. No one is going to stop you or take away that right from you. I know it can feel that way because it's a big, massive change, but that's not really the case. What no one in industry can understand is how the government cannot see that all the changes that are implementing and the way and the level, how far they go, can actually have an potentially adverse effect on the industry itself, putting far more pressure on the social housing sector, really.
So is there one more question? A few more here. The government might. There's quite a few more coming in there. The government might find the private rental market disappearing very quickly into Airbnbs.
That's a possibility.
Yeah. Does a lot of this still cover you if you're renting as a holiday let, or is that a different area altogether?
That's a different area altogether.
Okay.
Really. And Linda, you've made a good point. Some landlords will decide to convert to a short-term let. But that's not as an easy answer as someone might imagine. And while we don't do Airbnbs and short-term lets ourselves, over the years I have dealt with enough landlords who have been moving from short-term lets segment into the long-term residential lets. And having Airbnb can be as successful, but even more so has to be run like a proper business. And actually, it's very time consuming as well. So definitely some landlords will find this as a way of sort of keeping the asset and not selling it, while at the same time not being a landlord for long-term tenants. But it's not an easy answer. There is no question about that.
Caroline and Kate, they're. I think I feel the same, Caroline. This is, it is a lot to take on. So she's thinking she should sell all her properties and become a tenant herself, where she's going to be very well protected. And Kate agrees. There is going to be a lot of strain on the landlord, isn't there?
Yeah, absolutely. That's what I said about the rent guarantee and legal protection. The risks are definitely increasing, really. That means you have to charge the market rent, you have to have a rent guarantee and legal protection, and you have to run this as a business. By all means, be friendly with your tenants, but do not stop do not let this stopping you from running this as a business.
We have to be fair though, don't we? That even though there's a lot coming in to protect the renters, the likelihood is, there's a lot of information the renter will have to know themselves in order to, write to the tribunal or, go protect their rights. There's a lot that they're going to have to take on if they really wanted to take something that far. And the reality is most tenants and landlords relationships are okay.
Yeah, that's very true. So let's not fall in a trap to think that it's the end of the world. It's just things changing.
It's how this can feel, though, isn't it? It is how this can feel.
Absolutely. No. Listen, it's a big change, and with any change that we have that happens to us in our lives, it can be difficult to sort of deal with that change, and it does feel very, very different. That's what I'm saying. It's completely different situation in terms of being a landlord now to how being a landlord will be after the bill comes in already. The underlying reason for being a landlord, so having an asset that is to a certain extent financed by the rent the tenant pays, that underlying reason for being a landlord is not changing.
I can see we've got a few more questions to get through. So, Jenny, are the EPCs changing to C and above before 2028?
Jenny, no, they are not. So the timeline, very briefly, is we expect the legislation to kick in late 26. 28 is when by when all new tenancies will have to have the EPC rating C. So there will be sort of year and a half really of that period to do so, and then by 2030 all existing tenancies prior to that legislation becoming law will have to meet that standard. So if at 2028 you already have a tenant and your property is not meeting that C, let's say is D or E, you are fine until 2030. Okay. But comes 2030, this will become illegal and you will have to upgrade to C.
I've just noticed Jenny might actually have had to go, so we'll hopefully maybe get that information to her. But Miriam has to go. Susan's very happy that she's got to sell her parents' home. Yeah, that's fine, Susan. It's a good decision if you've decided it's right for you, especially after you've heard.
100%. I think we've got a question from James about rent guarantees and legal protections. So you have to be very careful when you decide on a provider for your rent guarantee and legal protection, because there are a lot of rules and conditions that will decide if you decide to make a claim, whether that claim is going to be accepted. And unfortunately, insurance companies not all of them are known to be easy when it comes to that. Sometimes the condition might be that you need to notify them that there are rent arrears within 7 days of rent arrears being in place. Well, nothing wrong with that, but unless you're keeping an eye on it properly, that the rent is paid, you might miss it by a day or two, and your claim will not be accepted. Right. Most rent guarantee and legal protection products will guarantee you a rent paid in place of the tenant for anywhere from sort of 15 to sort of 24 months perhaps. And normally what happens at the same time, they take on the process of evicting the tenant. Because while there is a limit on how many months rent they are going to pay in place of the tenant, they obviously, the idea is that they minimize that time. So they are very keen to obviously start the proceedings to evict the tenant. So that can give, a massive peace of mind, both in terms of not having the hassle of dealing with the process, as well as the knowledge that the rent is being paid. For existing tenancies, that is actually a little bit trickier, but most insurance companies will allow you to protect your tenants' existing tenancy, but normally you would need to meet certain conditions. So proper referencing of the tenants, and usually there is a period, often enough 2 months, during which you cannot make a claim, or the reason for a claim cannot start existing.
Okay. I don't know if you can see this one. Do you have any advice on FHH rules?
Caroline, perhaps you would be so kind to let me know what you mean by FHH rules, and if it's something that I should know. I'm sorry, my mind is blank, blank right now.
But email in. We have we got Slavek's email?
Yes, we will go just very quickly to last through questions. Okay, so again, question about staying as a landlord, whether it's worth it. We've covered that already. So David is asking, they are restricting your rights, the 12-month rule, when the tenants can go after 2 months. Yes, David, in a way, I guess you can look at it that way, but the view I would take is that while the tenancy starts as a periodic tenancy for the tenants, and it's some mistaken understanding of the government, the tenants prefer, periodic tenancy from day one, which is not really the case. You have to look at it as having a fixed tenancy for first 12 months. When it comes to your rights as a landlord, really. So that will be the change as well, really.
So all of these questions have been coming into question and answer, not chat.
Yes. So let's have a quick look through them as well. For 12 months, right now. Okay. So yes. So if you've got an existing tenancy and the bill becomes law, then that 12 months, the minimum 12 months, starts from whenever the tenancy started. So if your tenancy started, in January, and the new law comes in, in September, then that 12 months rule for the minimum tenancy before the tenancy can be ended would have started when the tenancy have started. At what point can you approach a guarantor for rent arrears? The very day the rent is late. That's the best rule for that. Okay, question about the rent increases. Surely you would ask for an unreasonable high rent increase so that the tribunal might give you a better rent than you might actually have asked for. No, Linda, so the rule about the rent increases, you increase it to the market rate, okay? Because if you try to increase it above the market rate, you give even more reason for the tenant to go to the tribunals than they would normally have. So it's not like every tenant will go to the tribunal every single time. So you don't want to increase the chances of that really. And let's face it, tribunal will not uphold the increase above the market rate. Okay. Can you claim a property back if you need it for an agricultural worker? So there will be in Section 8, one of the grounds will actually allow for serving a notice to end the tenancy because you need it back for for someone that works for you under the agricultural tenancy rules. Okay, there also be will there also be a similar ombudsman that the landlord can check upon the tenant, right? Okay, so I guess what Linda is asking is if there is ombudsman where the landlord can perhaps take it up. And the idea of ombudsman, the long-term idea is that the landlords should be able to use that to try to get things resolved before they are forced to go to court. Again, we are just waiting.
Yeah.
For the details.
So I'm conscious people might be having to go soon, so we'll try and get through them as quickly as possible. We've done that one, yes. So it's not possible to do short-term furnished lets anymore. Daniel's hoping to change one of her houses into this.
No. No, the simple answer is not. So you can have a furnished property that you would hope to be letting sort of more of a short-term rental, but the moment when the tenant moves in, they've got that right to stay in the property, and you basically won't be able to serve them a notice until you want to sell, you want to move back in, or they are in rent arrears.
So you could try to agree that mutually. I want to rent for 3 months. Will you have it available? But you couldn't force them to move
Absolutely
back.
Right. So as a long-term business, that's probably no longer possible, really. And if that's what you are doing, I would potentially consider, short-term lets.
Okay, and there's some.
Just for clarity, the short-term lets, the Airbnbs are not going to. The new law will not be applicable to them. For clarity.
So a few more questions here. PRS. Funding the PRS database?
No, so it's a question about the funding and the impact of who funds the ombudsman and the PRS database as to the potential outcomes. The short answer is no. Landlords are paying for it, but this will not impact on the decisions. Really, it's quite the reverse. Actually, you will be bound to have to follow the decisions of the ombudsman. So I wouldn't count on ombudsman being lenient to the landlords in any way, just because the landlords are the ones who are financing that.
Right. There's quite a lot of questions here. So should we go? There's quite a few from some of the same people. So should we go to a different person?
Yeah, let's go to the different person. Yeah, absolutely right.
What happens if they have a pet on inspection? There is evidence they are not responsible and the damage. What can we do then?
Okay, so that's sort of a good example. You with your property, the experience you had. So at the moment, you could potentially have served them with Section 21 notice. You no longer will have that option. So what that means is that a selection of the tenants will be extremely important. Carrying out inspections, letting the tenant know that the inspections are being carried out. That will help them not having an idea of having a pet because you haven't seen the property in years. And secondly, there are going to be again grounds that you can use to take action against the tenant, really, where you could try even to sort of look to evict the tenants, but this will be a discretionary ground with the courts, who will themselves be deciding whether the tenant should be evicted or perhaps some other solution sought.
So how do you prepare for checking the sanction list in relation to a landlord and selected tenants, and how do you provide evidence of this?
Okay, so just for clarity, the sanctions, the law is specifically aimed at the letting agents. However, the landlords still have to be mindful about it, because they run a business. Okay, and they cannot knowingly, even though they are not strictly speaking directly targeted by this legislation, are still bound to be vigilant and to ensure that they do not let the property to someone who could be on a sanction list. Perhaps that the risk of that in Shropshire is not perhaps as high as in London, really, but the risk is always there. For the estate agents, the access is through sort of all those companies that do the referencing, and I would imagine for private landlords that is likely to be the case as well. So whoever you are using to reference your your prospective tenants, check with them if they include the sanctions check as well. Okay, I think we've got just a couple of more questions here. Something to do with the EPCs. Right. Yes, so the EPC, so the government is trying to say that they are mindful that the EPC rules should be drafted in such a way that they take into the account that no two properties are the same. That's what they are saying really. How that will look in practice, we just don't know. So I can't really say any more on that. The sort of the way they are trying to suggest how the assessment is going to be made, I'm not entirely sure I would agree that this could potentially lead to sort of more damp and mold and condensation. Where you might be right is that currently gas is the cheapest way to heat the property, so replacing that with a heat pump might not actually be financially better option for the tenants, but the reality is that might actually mean that your property will meet the minimum rating C, whereas it wouldn't with other form of heating, even if it was potentially cheaper for the tenants. And the electric heating actually have made leaps and bounds in how efficient it is these days.
What about a property being 300 years old, so the rating will be very low? Can it exempt him from renting his property if it's not going to reach the EPC rating?
Yes. So if it's regardless whether it's an old property or not, you will be required to spend X amount of money. The 10 or likelihood £15,000 really to show that you are spending that amount of money. And if by then the property is still rating E or whichever that might be, then you can file for an exemption to say, hey, here it is, prove that I spent that amount of money. It's still not a rating C, so it will be fine. If it's a listed building, the rules are slightly different, but it's still really plenty that can be done with listed property. It's just that the work can be that much more expensive than with any other property really. So for example, if you've got a electric heating in the property, you perhaps may need to replace that heating with heat pumps, really as a way of trying to reach that minimum rating. So yeah, it's having a listed property will not sort of be sort of protecting you from the new rules.
Does the Renters' Right Bill apply to just England, or is it Wales as well?
It is just England. So the legislation around the private rented sector is devolved matter for both Wales and Scotland. But yeah, Wales got a different legislation, so this only applies to England itself. And as I say, Wales already have completely different set of rules from quite some time.
Okay, I want to give people the chance to be able to book a call with you, because we have run over a bit. So I do want you to be able to book a call, because there are questions we haven't quite got to. I can see them, but I want you to know that we've taken a note of them all, and we want to get back to you. But you can also schedule a free call with Slavek so that you've got more of those questions coming in, and you can go through them then with Slavek, and he can help you with your individual property needs.
Yes, indeed. I would encourage everyone. We've helped, plenty enough landlords. Some have just needed, some advice, better understanding of certain aspect. But and some landlords have come to the conclusion that actually it's it's now is the time for for them to sort of engage the professionals to do so, really. But yeah, it's going to be a different environment in being a landlord. It's all about, you know, answering that question. You know, do I need the asset, that property still, when it comes to sort of my bigger plans? And if I do, you know, do I want to carry on being a landlord? And the answer in most cases, I guess, will be yes. And then the final one is, you know, do I have the time to do so?
So if for any reason you can't book a call, I know that some people that had to drop off earlier said that they might email their question into you, but there was a lady there back in the question and answer who had a problem. Danielle, she asked for your advice. If you go up a little bit, this one. Danielle served a Section 21, but they've ignored it, and the local council granted them a license to do it. So she feels like her hands are tied. Have we got any advice?
Okay.
I don't know if she's still with us, but
okay. So the rules about and how the practicalities of council interacting with Section 21, if we can sort of put it that way, is that tenant is being served the notice. Tenant goes to the council saying, "Hey, I'm being evicted from my property. I need a new home. Please help me." They will sign up the tenant to a list of people waiting for the home, for a new home. They will allocate them so-called banding, so the priority. Normally, they will initially be quite a low priority in most cases, and they have to sort of bid for property. So if there is a property, available on the council through the council, and you know, two people are bidding for that property, whoever has a higher priority will be granted that property, really. And the council at the same time tells the tenant, under no circumstance vacate the property on your own volition, because if you make yourself homeless on purpose, and that would be the case if you do so without having a new home to go to, we won't have to help you.
But what about the fact that they have breached her contract in 4 different ways? So she can't get them out of the Section 21.
Danielle, so the again, practicality is the word I often use. Section 21 isn't really a discretionary notice. You should be granted a possession. So if you actually ended up going to court and you haven't been granted a possession of the property, that tells me there is more going on behind the under the hood. And my advice in that, if you are in that position, is to actually seek a legal advice from property lawyers, from lawyers who specialize in residential private rented sector. Which
I think she's done, and they said it would be the judge's discretion. Is there anything else she can do?
Not really. Not really. If they are paying the rent on time, and therefore Section 8 notice is not possible, Section 21 realistically is your only rule.
Can they start a puppy farm at her property that they're renting though?
They definitely can't. No.
But isn't that where the crux of the matter comes? They're renting from her and they've started a business there.
Yeah. So again, the inspections and all that, inspections and all that in place. So from what I understand, what you should do is to serve Section 21 notice, which you said you did, and it should be pretty straightforward matter when you go to court for the court to grant you a possession. So as I say, if you have not been to court, if you have been to court and you have not been given a possession, that tells me that there is more of a problem. In future, with the new legislation, as I said, there will be a rule about the pets where you can actually take someone to court.
There was another couple here from Linda. I don't know if she's still here. Can you refuse a tenant with children and pets if it's on agricultural property under health and safety for the humans and the livestock?
I would imagine so. That would be a reasonable consideration, really. But one will have to tread quite carefully. And the honest answer is we just don't know for sure what's the word? How that's actually going to be interpreted by the with the new rules. But I would say that sounds to me reasonable itself.
I think we have genuinely tried to switch between the two and answer all the questions. There's been another couple on here on the chat.
Yes, and I'm mindful that we are running to close to 2 hours of the webinar. Right, I can see now that it will be difficult for us to go through every single questions. Thank you for asking them. That is my favorite part of the webinar, but I wasn't quite expecting so many questions. So let me assure you, we'll make a note of those. Yeah. And in the coming weeks, through our newsletter, we will try to answer all of them. And if you if you still have a problem or an issue, just simply book a call with me. Get in touch. My email and the phone number.
Yeah, and if we haven't got to a question, I do apologise. There was so much to get through, but I hope we have answered the majority of them. And we will be doing another webinar, and we hope that you'll come along to it, because there is more.
There is more, yes.
But there will be more regarding the EPC, and you've asked some really, really valid questions. And the point isn't to scaremonger anyone. The point is to make us aware of what's coming and help us to all act appropriately around these changes.
Yeah, indeed. And I'm a little bit surprised that, we've got so many people still watching this webinar. I was expecting, we are hour and 50 minutes into it.
They've got wine. This is their
yes, indeed. And I've got just a glass of water, really.
But we hope it's been insightful. I think a lot of you have said that you have enjoyed it. It's maybe not the wrong word, because there's so much information, but you've got a lot out of it, which is what we hope for.
Yeah, and as we said, there will be another webinar. We'll discuss EPCs in more detail. There is time to do so. Really, there is going to be some planning needed to prepare for that. With the bill, again, once the legislation gets a royal assent, again, we will go through the important aspects of it in detail. But I guess what I wanted to stress is that in order to really properly to go through every single point and detail of the bill, we would need to have a webinar that sort of goes into quite a few hours, really. So it's important to keep up to date with the developments.
And we should just add, it's when it's implemented, even though we've said it will be implemented straight away with no chance for
implementation period.
Yeah, it will be straight away. However, as Slavek has tried to say, there is no case law against this at the moment, and that sort of thing will take time. So it's not like you've got time to make mistakes, but there is time for this to be embedded in realistic terms. Yeah,
that's right. Just quickly about the implementation. So once the bill gets royal assent, at that point, the government will tell us when it actually will, become a law that is applicable, really. So there will be a period of time, really. But yeah, that's a very good point. That the risk that anyone is running is that you will be a test case, really. Yeah. And that's you ideally want to avoid those situations.
Sarah has asked, when is the next webinar?
Yes, so it will be in 3 months' time, unless there is some urgent development, in which case we might decide to sort of run some emergency webinar at a short notice.
And we will let everyone that's
know. Absolutely right. Make sure that you are subscribed to our newsletter, because if you do unsubscribe from the newsletter, then obviously you will not receive the notifications about webinar or anything else that we've sort of got for you. But yeah, thank you very much.
Okay, thank you.
We really enjoyed it.
We'll
Thanks so much.
Again.
You have a good night.
Bye.